have Victoria Gribbin. She's my dear friend and my mentor, licensed LMSW, licensed master social work, licensed New York State social worker, ADAAA advocate expert. She's an expert. She's being modest with her little bio here. DV advocate, consultant, and retired New York City police officer. She's a forensic social worker whose area of expertise is the Americans with Disabilities Act, amended 2016 ADAAA, and Title II non-discrimination compliance regulations. Title II covers the courts, just so you guys understand. As they apply to family and matrimonial court contested lawsuit proceedings, custody, and related orders, she is a tireless ADAAA advocate for litigants with non-apparent neurologically-based disabilities, children, and domestic violence victims with 17 years experience, here to explain why the FJAA, Family Justice and Accountability Act, in case you don't know what that is needed to end rampant systemic Title II ADA discrimination and substantive rights violations by New York State's, well, this is national, guys, law court systems and the entire nation, based on her hands-on, in-court, grassroots knowledge, experience, and evidence-based research facts.
Okay, thank you.
Got the floor.
There's no way I can cover all this, and I'm only going to do it in about 3 or 4 minutes because I want all of you to get a chance to speak. I'm only going to hit a few bullet points because I'm sure I'll be able to speak again another time. I'm here to tell you why the Family Justice and the FJAA needs to be passed regarding the ADAAA piece, because let me tell you something. Every time a domestic violence victim or a child that has ACEs or has a disability, we're not talking about just physical disabilities, we're talking about any qualified disability under the ADA that was amended in 2016, depression, anxiety, ADD, OCD, so many of them, cancer, okay? They are a protected class member, okay? And if they are a protected class member, they're covered by the ADA, which are these statutes. And when judges do not apply these to orders or proceedings, they are using methods of administration, including rules and policies and procedures in their contested litigation. They do not have judicial immunity under the 11th Amendment. They do not. So, like Fran says, we don't need any other laws. They don't have the immunity. Not just because the family courts were not voted in by us. It's in the Constitution. It's in the ADA. And the Department of Justice, the reason why we need to pass this is because there's a pervasive disregard of enforcement by the DOJ. Now, what happened was, because the family courts they were getting flooded, they are now sending out, every time we file a Title II complaint, they're saying, we're not saying you don't have a case, we don't have the resources, we can't, so use an alternative method. What's your alternative method? File a federal lawsuit. Well, what happens? I even did that. What happens? They tell you, sorry, family court, separation of powers, barred by Rooker-Feldman, motion to dismiss. First of all, who even has the resources to go to family court, federal, if you have the money or the time? And that's another whole thing that's also the ADA doesn't apply to federal, but it's unconstitutional. If you ask federal courts to call the Department of Justice and Civil Rights Division, they don't do it. By law, they're not required to do it, okay? So we need the FJAA because the DOJ is not enforcing the ADA. It is leading to an epidemic of disabilities. It's a public health crisis. These family courts, they're creating disabilities. They're creating ACEs, okay? Yep. And the ADA has 2 fundamental principles: individualized treatment, full and equal opportunity. Every person who is impacted by coercive control through an order, financial abuse, we can't even get direct deposit for a financial add-on order. If a judge orders, okay, so you need money for therapy, you need money for prescriptions, I'd like direct deposit because he's never going to give it to me, then I have to file a contempt motion, then it'll take a year, or it'll say it's late. No, sorry, that's not the policy unless he agrees. whether the lawyer will fight it under the ADA. So that what I did was, okay.
You go, girl.
New York City policy is because I just want to, I kept on banging the drum in my own case, in other cases, and I kept giving accommodation requests to the jury duty guy because he was the ADA coordinator. And he goes, shouldn't you be giving this to the judge? I'm like, yeah, except that this is policy. And then when we wouldn't give it to the judge, he would say, I'm sorry, this doesn't apply. Your attorney is your advocate. The client's attorney is their advocate. And I'm like, no, you're violating the ADA. So finally, they said the judge is the only person who can give accommodations. And then if you disagree, take it up and file an appeal. And the ADA is an administrative process. They should do it right away if they're violating the due process. I'm sorry, no judicial immunity. We're on.